we have an emerging idea of what a holding company should look like. So this is a basic slide that what are the aspects of a new company, and you will certainly want to have a new company as soon as possible in the lifespan of your startup, because you want to capture intellectual property, you want to capture assets in that legal entity. And so starting with the SAPI from day one for your company that's operating in Mexico, where you don't have visibility of what your fundraising path or your growth path is a perfectly valid choice, just like starting with the Delaware Corporation for the U.S. investor, or U.S. entrepreneurs is a valid choice. But then we get to this stage of having to do a flip, having to set up a holding company. And by holding company, what that really means is an entity that holds beneath it one or more subsidiaries that actually run the operations. And the holding company itself generally does not have operations. It just serves as a vehicle for issuing shares to investors, to entrepreneurs, to the ESOP recipients, etc. And that's why it's called a holding. You, generally speaking, do not want shareholders at different levels of your corporate structure. You don't want to have investors at a subsidiary level and investors at a holding company level, because that complicates your governance and complicates your exit path. And so when we're talking about a holding company, 5 years ago in Mexico, in Latin America, the world started to get a little bit smarter about tax planning and corporate planning. And the Cayman Islands became a structure that was used. And so Confio, Corner Shop, a number of prominent startups in this market have Cayman holding companies. Why Cayman? Because there's no corporate level tax and there's no shareholder level tax. And importantly, the corporate laws are modeled after Delaware, so they're very flexible. You don't need to have board meetings on Cayman soil, even though it's a pretty beautiful place like it is here. You don't need to have local directors, local employees who are Cayman residents. But it's got the flexibility of good corporate laws and predictable corporate laws. And so Cayman is used quite frequently. Although there is an asterisk to that, which we will talk about in the tax presentation, which is in recent months, because of a tax reform in Mexico, the world has become a little bit more complicated in using holding companies that are Cayman holding companies. Cayman isn't perfect, right? So like anything, there's no one size fits all. And unfortunately, Cayman has bad optics. You know, there are certain family offices, certain investors who are not comfortable with Cayman, for a variety of reasons. Even though Cayman is a perfectly legitimate place to have a legitimate business, it still sometimes creates friction in the fundraising process. And so alternatives exist as well. The principal alternative for venture-backed companies in the startup world that we see is the UK. Why the UK? Because it has a tax regime, a tax set of rules that are friendly to holding companies that are not doing business in the UK, which Chris can talk more about. It has good corporate laws, similar to Cayman and Delaware. They're flexible, so you can do preferred shares, you can do safes, you can do an ESOP, you can do all of that. And I would say international investors are broadly comfortable with the UK. They've maybe made investments in the past. They generally can trust the UK from a governance standpoint, from an enforceability standpoint. We're going to be able to resolve a dispute in the UK fairly easily. All of those things matter. And so the UK has emerged as an alternative to Cayman and Delaware. We have several Mexican clients that have that structure. I said it wasn't perfect. Nothing's perfect, right? So the UK has certain things that make it a little bit less advantageous, in my opinion, compared to the Cayman Islands. One of which is that your financial statements and your shareholder list are publicly available in the UK Companies House, which is the online filing registrar that you have to make your filings with. And so technically your competitor has access to your financial statements. I think it's once a year, but nonetheless they may have good information about what your balance sheet looks like and how financially weak you may be, and use that to your competitive disadvantage by going after your employees or by using the information with customers, etc. And so for some companies that matters. Your shareholder list is also publicly available, and so your shareholders may not be excited about that. And neither of those two cases are applicable or They're not the case in Delaware or Cayman, that your financial statements and your shareholder list are publicly available. So there's those things that go into it. Once you have settled on what structure you want, and you also want to have the dialogue with the investor, as I mentioned, to make sure they're comfortable, then you go through the process of flipping from point A to point B, from your local structure to your holding company. And you'll want to put in place a set of steps that implement that. We'll talk more about that. And then you do the funding round. And from there, you've built a corporate house, you've built a legal structure that will hopefully allow you to scale, to fundraise further, and to eventually exit the business. The structures that we talked about all allow for flexible financing alternatives. Generally speaking, the key issues that go into the financing, of course, are the economic terms, valuation, dilution. But in my opinion, equally important are the governance terms, how much you're giving away in terms of your board and your shareholder rights. Making sure your liquidation preference looks very plain vanilla. The world of venture capital is largely a world of standard, templatized documents and terms that make the process as frictionless as possible. I think Eric said it before. I mean, there's enough friction in the fundraising process that you don't want to add legal terms to the list of frictions that are it's already hard enough to fundraise. And so those terms, for the most part, are becoming more standard in Mexico, but there's still some divergence between local investors and certainly family offices and other non-traditional investors, but the world is evolving in that direction. Generally speaking, if your goal is to continue to fundraise in international markets, you want to make sure your local fundraising round is on those terms that are similar or that will be familiar to the future international investors. Because the terms that you will live with at your seed round or your pre-seed round will likely set the precedent, will set the framework for future rounds. So if you agree to a 2x liquidation preference, which means the investor gets 2x their money back before the founders or common shareholders receive anything, in your seed round, your Series A, your Series B, etc., investors are likely going to ask for the same. So that cat has gotten out of the fence. So you want to make sure your terms are customary. And obviously working with a law firm and tax advisors to help you set those terms is very important. There's a set of cross-border investment considerations which go into effect when you're raising from an international investor. And depending on who they are, some of the impact funds in particular, like Acción and Omidyar and other funds like that, have increasingly focused on social, environmental, and other metrics, and they'll ask for a set of policies that are in place with anti-money laundering and social impact. So just be prepared to know which type of investor you're talking to and what their needs and internal requirements are. There's a set of planning that goes into putting in place transfer pricing and IP protection. You want to be thoughtful about that. You want to be thoughtful about your cap table and making sure that your option grants are properly documented, because of one area where in the future, if you're selling your business and you're going through an M&A due diligence process, you need to have 100% integrity of your cap table. You need to know that everyone that owns a share that's promised an option or has a warrant is entitled to the specific number of shares that are listed in the cap table, and there's not going to be anyone that comes out of the woodwork in the classic Facebook example when they claim a share of the company down the road. Regulatory matters really depends on the type of business that you're in. Obviously, healthcare, insurance, medicine, of course, as I mentioned, those are heavily regulated areas, and so we've been working with companies recently that are in the insurtech space that are going through local regulatory approval processes with Cayman holding companies, and we're getting the local Mexican insurance regulator comfortable with that structure. COFESE, the antitrust approval regulator, has also gotten comfortable with that structure, but you want to have a dialogue about it. So very, very high level, those are some issues that go into the thought process around structuring your funding round. As Andreas mentioned, we're going to be here tomorrow for a workshop as well, so there'll be plenty of time for more detailed analysis, and there's going to be a Q&A at the end of today's session as well. But I'm going to hand it to Chris to now talk through some of the U.S. tax implications.
Thanks, Dan. I really appreciate it. Hi, everybody. How are you doing? Everybody awake? I know it's the middle of the afternoon. I'm kind of snoozing myself. So, okay. So let's talk about where we start with. So we talked a little bit about where you start, right? Here's your SAPI. You're a brand new startup. You know, you're doing your thing. You're building your business model. You got a few investors. This is where you start. Now the question is this where you're going to end up? And unless all your venture money is coming from Mexico, this is not where you're going to end up. We have this thing called a flip, which Dan mentioned, and the point of the flip is really to put a new holding company on top of your Mexican operating company. So here's your SAPI, this is where you start, and the flip itself mechanically is fairly simple. You know, it's a share-for-share exchange. The cap table before and after the flip mirror. Sometimes we see convertible debt or safes convert up at the time the flip happens. Now we got a couple of goals with this. So when you do a flip, though, Mexico doesn't always have the most friendly rules in this regard. You know, so we've got to be careful. We want it to be tax-free for you to get into the new structure. We want to make sure that it's attractive for later rounds of investment. We want to make sure that it's a good platform to grow your company. Sometimes having those Cayman structures actually make expansion into, say, Brazil or other Latin American markets easier. So we want to create a platform where you can grow the business cross-border if that's one of your goals. Most importantly, you want to maximize your return on the exit. You don't want to give too much to the government. And we also want to create flexibility where we can for different exit scenarios. I know as you're just starting your business right now, it's hard to think about, well, what's that exit going to look like? But you really do need to think about it now because the decisions you make today can impact what happens later, and pretty profoundly. So we're going to talk about, you know, the typical U.S. holdco. I know there are seed investors that have been down in Mexico for a long time and say you got to put a C Corp on top of it. And you know, they're going to force you to do this, and I would push back as much as possible. A C Corp works in two circumstances. If your market's in the U.S., if that's your primary market, like La Vida Magnetics, and Alberto was talking about that earlier, you know, where the company came in from Chile and the main operating company is in the U.S., that works great. The second situation where you want a C Corp or a U.S. C Corp is great is when you think your exit's going to be to a U.S. buyer. You know, when you're ultimately going to sell to another U.S. company. Okay. Maybe those fintechs, that C Corp's a liability. These C Corps are often required by early stage seed investors. They're inexpensive to set up. Sometimes they do have some tax benefits on occasion for U.S. investors. This qualified small business stock. It's not going to help most of the people in this room. You know, drawbacks is it's a double tax structure. Sometimes it's a triple tax structure, and we'll show that in a second. Once you're in, they're very expensive to get out of. We'll talk, and if you've got C Corps that are problematic, we're going to talk about those in more detail tomorrow, because we've been working around these C Corps in problematic situations for a couple of years now. And then your later investors may not want to invest in the C Corp, and I'll give you one example. And we've been authorized that we can talk about this, but we were working with Connecta, and they're in all the OXXO stores, and they had a C Corp. And their strategic investor, their Series A investor, said no C Corp. And we're like, okay, now what? And so we had to structure around the C Corp, trying to maintain as much value for the founders as possible, because in this case, the Series A investor was a Mexican multinational. They don't want anything to do with the C Corp. It just leaves money on the table for them. It creates an extra tax